Lawyer time, our favorite time of our radio conference because it's free. We'll have questions after. Kathleen will give us updates on FCC, and then we'll have a break, and then we'll come back and ask questions. So hold on your questions until after the break. Thank you.
Maybe I'll take a look at that. What if something...
Okay, better? All right, good morning. Good to see everybody. We didn't have a show last year, so I haven't seen you in a little bit. I am Kathleen Victory. I'm from Fletcher, Heald, and Hildreth, as most of you know, and I have been representing some or all of you for years, and the firm has been representing some or all of you for a lot longer than that. This is my colleague, Mark.
Hi, everyone. I'm Mark Malonzo. It's a pleasure to be here. Thanks for having us.
I am, and this is an official announcement, I am retiring at the end of the year, and Mark is going to take over for me. So, take a minute to introduce yourself, get to know him. You're in good hands with him. We are going to talk about a number of things. There's not a huge number of FCC issues out there that are really pressing, although the FM translator window is a big one, and we'll start off with that. As Ron said, we will do questions at the end, although if you have a really, really pressing issue beforehand, feel free to raise your hand. We'll take anything you want. Okay, so with that, we'll talk about a number of different issues, but I'm going to start with the FM translator window. It's expected to happen. We don't have a date yet officially. It's expected to happen in late 2026. I think the earliest would be mid to late November, but it's hard to know yet because the FCC has not established a definitive date, nor have they established definitive terms for what's going to happen. They've established some basic guidelines, and they are in the process of working through the whole procedural order. I have put a number of questions to the FCC staff, and so far, it's as recently as Friday, they have come back to me and said they don't have anything that I can share publicly. So I do want, after I finish my spiel here, for any of you who have specific questions about the window and what's going to happen in it that didn't show up in the public notice that was released, to feed to Mark and to me questions that we can then feed to the FCC staff so that they will consider those questions before they come out with their procedural order. Always better to try and get them to consider things before they come out with an order rather than having a lack of clarity going into a window. So with that, the window will be for FM translators in the reserved band only. So on channels 201 to 220. Has to be on the reserved band. The applicant must be non-commercial educational, nonprofit, and the applicant must also be the licensee or, and this is one of the questions that I asked the FCC, a licensee or permittee of an existing station, AM, FM, or LP-FM. Lots of questions related to LP-FM, and we'll get to some of those, but there are also a lot of questions that I've put to the FCC staff, and we'll try and feed you answers as soon as I get them, but as I said, so far nothing. The public notice gave very little detail in the scheme of things. What it did establish is that a licensee of an AM and FM station can file up to 10 applications for new FM translators. For tribal entities, they can file up to 4 applications. For LPFM, you can file up to 2. But bear in mind that if you already have 1 or 2, you will not be able to file for more, at least based on what the FCC has told us so far. If you don't have any, you can file for up to 2. It's the translators, because you're non-commercial, will not be limited to fill-in facilities. You will be able to extend your primary service contour by using an FM translator. But one thing I would call to mind is that if you file for an application and it is mutually exclusive with another application filed in the window for an FM translator, the FCC will favor the fill-in over the non-fill-in, based on what they've said so far. It's pretty limited. There will be a permanent tie between the the FM translator, the new FM translator granted in the window, and the primary station license that it will be rebroadcasting. Meaning that if you sell the station, you have to sell the translator. Or if you sell the primary station, whoever continues to hold the license for the translator will have to continue to rebroadcast the same primary station. You can't disconnect them. There will be a permanent tie. No party to an application for a new translator in this window can have an attributable interest in an AM, an FM, or another LPFM. That's very, very important, and that's the one thing we know that they are absolutely going to restrict. Right now, the rules say you can only have one LPFM, but you also cannot have an interest in a full power station as well as an FM. Now, a little bit later on, we'll get into some things that you can do to expand your coverage without running afoul of the rules. I have asked the FCC staff about geographical restrictions. The order that came out so far, the public notice that came out so far, doesn't give guidance on that. LPFM has existing restrictions in the rules, and the FCC, at least in the initial public notice, has not indicated that they are looking to waive or modify any of those existing restrictions under the rules. And Mark's going to get into the eligibility rules for LPFMs next, and that relates specifically to this because you will have to comply, anybody filing for an FM translator for an LPFM will have to comply with the LPFM rules in terms of eligibility for filing. I've asked about geographical restrictions. I've asked about signal delivery restrictions because, as you know, with FM translators for LPFMs, if you own the translator, there are restrictions on signal delivery. You have to deliver over the air. I've also asked about whether a permittee of a new LPFM station that has not yet been licensed can file in this window. They haven't answered those questions. If you have other very specific questions, please let us know so that we can pass them on. So that's really where we are on the LPFM window, and I know there will be questions, but allow us to keep proceeding through our related issues to some extent, and then we'll go back and take any questions that you'd like. Mark.
For LPFM eligibility, in contrast to the translator window, but related in the sense that, as Kathleen mentioned, applicants will need to maintain LPFM eligibility at the time of applying, and in fact, as is the case with holding an LPFM authorization at all times. Well, eligibility, what does eligibility entail? First off, the applicant or licensee needs to be a nonprofit educational organization, and at the application stage, that involves also showing that the station will be used for advancing the educational mission of the applicant. The more interesting part of eligibility is being a local nonprofit. There are two ways to prove that you are a local nonprofit. The first, to satisfy the local requirement, the entity's headquarters or one of their campuses must be within 10 miles for stations in the top 50 urban markets, or 20 miles for all other stations of the transmitter. So that is, within 10 miles or 20 miles of the transmitter, you must have your headquarters or one of your campuses. The other way to satisfy the local requirement is to have 75% of your board living within those same distances, 10 miles, top 50 urban markets, 20 miles for all other markets, within 10 or 20 miles of your transmitter. With regard to ownership limits, may only have one LPFM authorization, and no board member may have an interest in a full power. That's one aspect of eligibility that gets overlooked, and that becomes especially important when it comes to LPFM transfers of control and assignments. Historically, the FCC has been pretty lenient, comparatively at least, with non-commercial stations. But there is rumor that, as many things, that could change at the FCC. So just to review some pretty important rules, it's important to monitor your board changes over time, both complying with LPFM eligibility, as I discussed a few seconds ago. As your board changes, you may, if you're relying on that 75% of your board residing within 10 or 20 miles of your transmitter, you may lose that eligibility if you let your board slip away and you don't keep your eye on the changes over time. But also, it's important to file before at least 50% of your board. So before 50% of the board vote has changed hands, you need to get permission from the FCC by filing and being granted the transfer of control application.
I'm going to interrupt you.
Yeah.
Mark is absolutely correct that the goal is to file before you reach the 50% change of control in your board. The FCC, as Mark has indicated, has been fairly lenient in looking at changes over time. So if you file very quickly after you reach the 50% threshold, that's generally acceptable, but the goal in life is to file beforehand if you can.
Absolutely. And with that 50% is benchmarked or with reference to your most recent filing of a transfer of control or assignment. So you reach that 50% change in voting power based on the board that you reported on your most recent transfer of control or assignment. With respect to assignments, quick overview of some of the rules. Consideration should not exceed the legitimate and prudent expenses, in the FCC's terms, of obtaining and constructing your station. Consideration is not only money. That's important to keep in mind with all FCC matters, assignments as well. And in terms of consideration, there is no permitted recovery of operating expenses. So unfortunately, the FCC does not account for the fact that folks expend quite a great deal of resources in running their stations. So consideration can't include any of those expenses. And as is the case with transfers of control, and the headline I hope to drive home here is that the assignee or transferee must be LPFM eligible at all times, not just the time of application, although especially at the time of application, but always.
Well, the FCC will come back and ask for proof of the compliance of board changes with the eligibility, the distance requirements and the local eligibility requirements. We have to literally submit maps showing the distance between the transmitter site and the church or your headquarters or your campus or whatever. So bear that in mind all the time. One thing, a lot of LPFMs, this has been my experience, a lot of LPFMs forget that they have a requirement to tell the FCC in advance or very shortly after that they've had a change in their board. Please, please, please don't forget that. As we will discuss a little bit later on, the renewal cycle is coming. It'll start next summer. Now's the time to be looking at your ownership. Now's the time to be looking at your record keeping. Now's the time to be looking at and correcting any problems that you have, because if you can go into a renewal with the ability to certify that you're in compliance, you're a whole lot better off than having to do a mea culpa and take the chance of getting fined. So OPIF.
And just one final note on those transfers of control. It could help, suppose you keep in your office a file that you crack open once a year and use with respect to board changes. If your board does change once a year, it could help just to keep a little tally, you know, even just on the folder itself, tracking when you're going to reach that 50% benchmark. And please give us a call, let us know if we do represent you.
Well, and also keep a record of when each board member got on the board and when each board member leaves the board, because that's part of what we have to show to the FCC in filing a transfer of control application for non-coms.
And with that, turning to public files. Full powers have an online public information file. LPFMs do not, but as we'll get into in a little bit, LPFMs do have some record-keeping requirements still. But public files, as the full powers will know, contain broad swath of documents, some of which should be automatically uploaded. In case they aren't, please just take a moment to look at your public files, upload those documents if the FCC hasn't done what we think they'll do, and they have been doing, which is uploading your licenses, contour maps, and with respect to organizational documents, you should keep those in your file. The FCC is not uploading those automatically. Bylaws, articles of incorporation. You can do a list of those documents, just a document describing those things, say saved as a PDF, or the actual documents themselves if for some reason you prefer to upload the documents completely. And that does actually include network affiliation agreements. So if you do have one of those, please make sure that that's either on your list, on your OPIF, or uploaded to the relevant folder on your online public file.
Also, one thing as far as your organizational documents, as Mark said, you can either upload the document or you can have a list. If you do upload a list to the online public file, you have to make them available if anybody asks to see them.
And with respect to issues programs lists, another important and often one of the more cumbersome record-keeping requirements. Issues programs lists are due quarterly, January, April, July, and August 10. January, April, July, and October 10, October 10. And keep those in your public file until your next renewal is granted and that grant becomes final. Those record-keeping requirements are important. The retention requirements, just in case the FCC does, in the process or at any time, take a peek back in that folder, and then upon that grant of your new renewal becoming file, you're good to clear out your issues programs folder and start filling it back up as time goes on.
One other factor as far as the online public file is concerned, remember that now that the online public file is located on the FCC's website, it tracks exactly when you file. So if a document is due by the 10th of April, you have to upload it by the 10th of April. If you don't and you file late, then you have to disclose it on your renewal. You have to disclose all late filed documents. In renewals, that's one of the biggest bugaboos that the FCC looks at. Failure to comply with the online public file rules is a huge bugaboo that leads to fines and or consent decrees and compliance reporting. It's keep up with the rules. Easiest.
And to the extent that you might have fallen off just a little bit, it's best not to get discouraged. Just get back on as soon as you can. Pick up by catching up and then meeting the deadlines. The more you demonstrate to the FCC, there is still time that you can meet those deadlines and have uploaded what was outstanding, the better chance that the consequences will be small, maybe even in a Goldilocks scenario overlooked, but at least minimized. Political files also belong in the public files, and we'll have more on that in a little bit. With respect to donor lists, important for non-coms, the donor lists that you upload need to only list donors who sponsored particular programming. So suppose you have a sponsor that just generally supports your station. That would not necessarily need to be someone you list on a donor list. The only donors you need to list are ones who sponsor particular programming. And keep those in your public file for 2 years after you've aired the programming that they have sponsored. With respect to third-party fundraising, and that's something I'll get into in just a little bit, those deadlines track the issues programs deadlines, January, April, July, and August 10th. So for those uploads, third-party fundraising could help to just keep in mind, link those to your issues programs uploads, do a check-in, make sure that quarterly you've kept up with both those requirements. EEO files for entities who do have those obligations also belong in the public file, and one of the supposedly auto-uploaded, but still please check, documents is FCC applications. Please make sure those are uploaded to your public file.
As far as the online public file is concerned, as all of you are probably aware, the FCC actually has a link in the public file that tells you what documents have to be uploaded and how long they have to be maintained there, which is why we didn't get into, terribly detailed discussion of what needs to be uploaded. But we're here if you have questions about what needs to go in and how long it has to be maintained. The other comment I would make is before we get to renewals, go in and take out of the online public file anything that you are no longer required to have in there. Don't keep the historical documents in there forever. It just creates room for mischief. In recent renewal cycles, there have not been a huge number of challenges against renewals, particularly radio for small operators. Big operators, different thing. But if you leave documents in there that are old and no longer required to be in the public file, you're opening yourself up for some person to come in and look at it and say, you did it wrong, and this isn't right, and that wasn't right, and get it out of there if you're not required. So that's one of the things I was going to say in ramping up and getting ready for the renewal cycle, which will start next summer. Go through your public files and make sure you get stuff out of there. So that takes us to the next, which is, and I know there had been questions raised about record keeping generally, both for full power stations and in particular for LPFMs. The rules haven't really changed for AM, FM. You've always had to maintain a public file, and you've now heard what you have to have in the public file. But in addition to all that, you have an obligation to file, full powers have an obligation to file biennial ownership reports. They're ordinarily filed in November of every 2 years. The biennial ownership filing has been suspended by the FCC until June of 2027. So there is no biennial ownership reports due this year. They're due in odd years, so it wouldn't have been this year anyway, but ownership reports will be due in June of 2027 unless they do away with it before that. EAS, all stations, LPTVs, LPTVs and, not LPTVs, I apologize, LPFMs and full power stations are required to have EAS equipment and to maintain logs of all activations and reports. All stations are required to push the codes. They're not required to initiate codes. You don't have to initiate EAS codes. You do have to pass them through. You do have to monitor your 2 monitoring stations. You do have to comply with the ETRS filing deadlines. Ordinarily, the FCC does an annual nationwide EAS test. Last year they did not, but that did not eliminate the obligation to file ETRS Form 1. I inquired of the FCC this week whether and when the nationwide test would be this year, and they said they don't know. Obviously, if they announce that there will be one, we'll tell you when it will be. We will push out a notice to all of you to let you know when it will be, when the ETRS form will be due, even if they don't do the nationwide test. And if they do the nationwide test, you would also be responsible for filing ETRS forms 2 and 3. Those are filed after the test. ETRS 1 is filed on the day of the test. And that is something that they do look at. I don't know of anyone who's ever been fined for not filing the ETRS forms in a timely manner, but they do, under the rules, require that the ETRS form be filed on the day of the test, and then ETRS 2 and 3 have specific deadlines afterwards that are established by the FCC. So as I said, you have to have logs that list all of the tests and activations, weekly and otherwise, and that's true of all stations. Logs, generally, you have to keep them for at least 2 years. They can be electronic or they can be on paper. You need to keep logs of tower lighting and checking your tower lighting. You need to report station outages, station operational variances from your licensed parameters. If you have equipment go down and equipment repairs are made, notations should be made in the logs at the start and finish of each. The logs themselves should have the time, the date, and should be signed by the person making the entry in the log, and the logs are retained for 2 years. STAs. If a station, and this is all stations, if a station has to, for whatever reason, operate at variance from its license parameters, then you have 10 days before you have to notify the FCC. If it is anticipated that that variant operation will continue for up to 30 days, then at the 30-day mark you have to file an STA. STAs can be engineering STAs, meaning you are operating at variance, or it could be a silent STA. STAs are granted, generally speaking, for 180 days, and you can, if it's an engineering STA, you can continue to ask for renewals of the STA as long as you are able to provide a justification. In other words, you can't just sit on your hands. Now, that said, with a lot of circumstances, especially if it's financially driven, you need to get a new transmitter and you haven't raised the money to be able to buy a new transmitter, you have to get fancy with your words. Bottom line is, we can help you with a justification if you need justification, and you can almost always get an extension of an engineering STA. After about 3 years, the staff starts to push back. So, you can't go on forever and ever, but you can go on for a bit. Silent STAs. A station can be silent for up to 12 continuous months. If you go 1 day over, the license expires by operation of law. There are virtually no exceptions. And nothing that you can control is an exception. The one exception that the FCC readily looks at, doesn't always accept, but looks at, is local litigation. If you've got somebody, for example, if you've got a zoning issue that's preventing you from being able to make a modification, an approved modification of your facility, and you end up either at a local or state bureaucratic office unable to comply with their requirements or unable to get an answer out of them as to whether or not you may proceed, then you can use that as a basis for being off the air for longer. If you're going to do that, you have to file well in advance, because otherwise you risk the chance that your license will automatically expire at the 12-month mark. You can't file on the date, the day before your 12-month period expires, or you're dead in the water. So bear in mind, you need to let us know early on that kind of thing. With LPFMs in particular, there was a question about minimum operating schedules. There is, in fact, a minimum operating schedule. You have to operate 5 hours a day, at least 6 days a week. I haven't seen the FCC go after anybody, but that is something that might be done behind the scenes, so we wouldn't necessarily know. It wouldn't have been, there wouldn't have been a writing issued to the public. But be careful to make sure that you're operating with a full operating schedule. Let's see. Okay, another question that y'all raised was how to expand your LPFM coverage. There are limited opportunities for that. because you can only own one LPFM, and you can't own an AM or an FM. You can use translators to expand your coverage, and there are minor differences, but differences between FM translators that you own, limited to 2, as we discussed earlier, and translators that are not commonly owned. There is no restriction under the FCC's rules on how many FM translators you can use with your signal if you do not own it. So that is a good opportunity to be able to spread your signal. It's not required that they be fill-in because you're non-com. So that gives you an opportunity. You do have to, for translators, as we said before, you have to use over-the-air to receive the signal. You can't use microwave, you can't use internet. Bear that in mind, but you can still use other translators. I'm actually hoping that in the window they may lift that over-the-air requirement, but so far there's no indication that they will. Another opportunity for you is HD. LPFMs can operate in HD. You can implement an HD operation which can give you 3 additional channels. The requirement there would be that the HD1 rebroadcasts the primary signal, the analog primary signal. But you can use HD to expand and get your signal out there. You can have an FM translator rebroadcast on an HD channel. You don't have to have prior approval from the FCC to have HD, but once you've implemented it, you file an HD notification with the FCC. That's supposed to be done within 30 days of going on the air. With full powers, you actually are supposed to file in advance, but for LPFM, you are allowed to simply notify the FCC. One thing to remember is if you go HD, your EAS must have the ability to interrupt on all of your multicast channels. So not just the primary. You have to be able to interrupt all channels with your EAS to pass through. That's, as of right now, unless I will defer to Bob, who will tell us if there are other engineering ways to expand your coverage. But right now, that's pretty much, from an FCC legal perspective, those are your options. Now, one other thing that I will mention, and you have to be very, very careful with this. Tom has done this. You can have another entity. You can have another church. You can have another chapter. That chapter has to be separately incorporated, and there can be no crossover of the board. But you can have another entity that obtains an LPFM and translators in your general area, as long as you comply with the FCC's technical rules, which Bob will get into. But you do have to be careful of that because there is the need to have separate operations and separate entities. I know that I've had this discussion with Tom in the past. You really shouldn't be operating from the same location, the same studio, because the closer you get in operation, the closer you get with programming and with location, the more it looks like you're not independent. So while you definitely can do it if you have a separately incorporated entity, I would admonish you to be careful how close you let those operations be. So, that's all I'm going to say on that at this time. If we have questions, we can certainly talk about that later. So I'm going to leave to you to delete.
Oh, yes, for delete, delete, delete. The comment period in the FCC's delete, delete, delete proceeding, that is the one considering phasing out particular rules phasing out particular rules that
are no longer
applicable, has ended, but we've put in a question to the FCC and heard back that even if the comment period has ended, people interested in having a rule, at least interested in communicating to the FCC that there is a particular rule or rules that could be considered in delete, delete, delete. You could file a petition for rulemaking if you choose to go forward and submit something yourself. The electronic comment filing system, ECFS, is available. It's an FCC website, and we would be more than happy to put together a petition for rulemaking if you'd like to work with us. And it's important in those comments, or excuse me, in those petitions for rulemaking, just to make clear, because it is a little bit unconventional to submit after the comment period. Just mention in the very beginning of whatever you submit that you're writing to express that there are certain rules that you would like to be considered in connection with delete, 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 and that, based on the source in the FCC, should do it.
Okay, as I mentioned earlier, the radio renewal cycle begins in June of 2027. Renewals are filed on a rolling basis, on a state-by-state basis. They alternate months, and then every state or several states file within one window. The renewal applications themselves are filed 4 months before your current license expires, and generally, if there's no problems with the renewal will be granted before your license actually expires. That said, you are protected by filing on time. If you file your license application, even if there's a problem or even if the FCC runs behind in time, your license does not expire until the FCC acts. So, as I said, it's staggered by date. I have a list of the renewal dates if anybody wants to come and see when their renewals are due. As I alluded to previously, the time now is to look at your record keeping, to make sure that your logs are in order, your EAS is in order, your issues programs are on file, and if they weren't filed timely, let's get them filed now so that when we file the renewal, we can say, this wasn't filed on time, but we discovered and we corrected it, and this is what we're doing to make sure it doesn't happen again in the future. Make sure that your tower lighting is proper. Make sure that if your tower lighting goes out, you file a NOTAM, a notice to airmen. I can't remember what that, but with the FAA. Make sure that if you are operating at variance, that you have an STA on file. Just make sure you're generally in compliance going into the renewal, because you're much safer being able to go into the renewal saying that there may have been a problem, but you acknowledged it, you found it, you fixed it, and now you're going forward and you're in compliance. As I said before, be mindful of the fact that where you have uploads that are required by the FCC in certain time frames, that you have to do it within that time frame, because the FCC system now timestamp absolutely everything. So you don't want to have a gotcha. They can see exactly when they were filed. I had an issue with, and this is television or LPTV as the case may be, but I had a client that filed their issues programs lists at midnight California time. And on the FCC side, which is on the East Coast, it showed that they were filed 3 hours late. So be mindful. The FCC can see all that.
With respect to the public file, just on the off chance that you do submit something, whether it be on time or even just a little bit late, and you later on find out that, oh, I submitted the wrong version, or oh, I omitted some important information, it's very important that you not delete the initial submission, because that timestamp can at least clear your name at least a little bit with the FCC.
Establishes compliance.
Yep, you did your very best to timely comply, and when you do subsequently upload something, the correct version, say, just
do it as an amendment.
Helps to put a note at the beginning of your filing that this is in connection with X upload, and this version you're now uploading contains corrections, something to that effect.
That happens fairly frequently with EEO. Now, and we didn't get into this, but EEO really, the EEO annual public file report only applies to, it doesn't apply to LPFM at all, but it applies to AM and FM only if you have 5 or more full-time employees. Full-time is defined by the FCC as consistently working 30 hours or more per week. So if you have an entirely volunteer staff, you don't have to worry about it. If you do have 5 or more actual employees under the state rules, then you would have to file an annual report, which tells who was hired, what resources you relied on. That said, even if you do not have an obligation to comply with the annual EEO public file report, you do have an obligation to comply with the FCC's EEO rules. You just don't have to file a report proving it. So keep that in mind. And you have to comply with the rules even if you have less than 5. So you're required to recruit for every position. You're required to keep records in-house. You're just not required to file a report with the FCC. So what's next? Music licensing. That's you.
Neither Kathleen nor I specialize in music licensing. We do have a couple of attorneys who are best equipped to advise on that, but I thought it would be a good idea to just give some practical pointers on the music licensing practice, and that is if you are using programming that includes music, particularly if you did not create that programming, you aren't certain whether that music is royalty-free, and by that I mean really 100% certain that every piece of music in that program is royalty-free, it's a good idea to have the licenses. There are 3 performing rights organizations that would cover most bases. That's ASCAP, BMI, and GMR. And the last of those 3, GMR, is a particular stickler. They do charge high license fees. They have a very small library, and very little of that small library is actually music that non-coms like to play. So it would be worth examining, and there are websites online where you can search what these performing rights organizations call their repertoire. If you search that repertoire and do not find music that you play, the music you play or is in your programming is not within GMR's repertoire, you do not need their license. It's important to be certain, because their enforcement action is expensive.
Yeah. GMR is very aggressive, very, very aggressive, but they have a small catalog. Their catalog is increasing over time, but they are very aggressive. They also make searching for their catalog more difficult than the other licensing organizations.
Yeah.
We do have people in-house that can help you with that. If you need help finding or determining whether or not music that you're playing falls within the GMR catalog. So you're done?
Yep.
Okay. We talked on this a little bit before. Ownership reports. LPFMs are not required to file biennial ownership reports, but LPFMs are required to let the FCC know when their ownership changes. So you do have to file an ownership report recording your changes, and then once you reach, as we discussed before, once you reach the 50% level of change of your board over time, then you have to file a transfer control application. FM stations do have to file biennial reports. They're due in October, but it's been delayed until June of 2027. The FCC is not, well, they're forgiving of full powers as well for changes over time. They've been more forgiving recently. But again, I would be very mindful, especially going into your renewal, because there's questions on the renewal about whether or not you filed your biennial reports and whether or not you comply with the rules related to changes in ownership. So look at it now. Now, I went through this with a number of you because the FCC came out saying that if you didn't update your FRN information within 10 days, they were going to start fining people. Well, it turned out that it only applied to a subset of operators, that didn't include you guys, but that was after I had already sent out all the emails saying you need to do this, you need to do this. So in updating your FRN information for many of you, I discovered that in fact there had been a transfer of control. So we've been playing catch up. But with the renewal cycle coming, take a look at your most recent ownership report or the most recent ownership that you reported to the FCC and make sure that your board has not changed more than 50% since that last filing, so that we can get a transfer of control on file now, have it done before we get to the renewals. Far better to handle it early and again, be in compliance at the time that we file the renewals. What you really want more than anything is for a renewal to simply slide through. And there really isn't any reason why it shouldn't. But let's keep up with the rules now, do it in advance, make sure that we're all in good standing by the time the renewals come due. Okay. Oh, we talked about some of that already.
Right.
Oh, but the third party.
Just to move on to third-party fundraising. NCE stations may interrupt their regular programming to conduct fundraising on behalf of third-party nonprofits. The time that a station spends doing that cannot exceed 1% of their station's annual airtime. So if you're interested in doing this, go back. The FCC says it's okay to use annual airtime from last year. So take a look at your last year's annual airtime, no more than 1% this year. You can't spend more than 1% of that time this year on your third-party fundraising. That third-party fundraising must interrupt regular programming. This can't be a regularly scheduled program, no matter how brief. So it's best to make very clear when you do air these things that you are stepping out of your usual programming for this special fundraising program. You need an on-air disclosure saying that the fundraising is not for the benefit of the station, but for, and then insert the name of that third-party nonprofit for whom you are fundraising. That needs to go on once per hour, as well as at the start and finish of your third-party fundraising program. You may be reimbursed for expenses incurred from that third party for whom you are fundraising, but that's the extent of consideration that a station is allowed to receive, just reimbursement of expenses.
Well, remember that third-party fundraising has to be for a nonprofit.
Yes.
It has to be for another nonprofit.
Absolutely.
It can't be for a for-profit entity.
And in terms of uploads to a public file, should you do third-party fundraising, again, for a nonprofit, there are a whole host of things that you need to list: basic biographical information, date, time, duration. But the most noteworthy part of this is that if your station was part of the process of tallying the proceeds, or you received those proceeds on behalf of the third party, you need to state the approximate amount of funds raised in your upload to your public file. And again, that's only if you were tallying or receiving those funds on behalf of the nonprofit.
And those are done quarterly, correct?
Those are done quarterly, linked to the same deadlines as the issues programs. That's January, April, July, August, 10th. October, I'm sorry. October 10th.
Okay, we have two more issues. Political, which is, you know, as a general rule, you as non-coms know you can't sell time, and you're not allowed to advocate or endorse a particular candidate, because that runs afoul of the FCC's rules. So as a general rule, you don't have a whole lot of obligations as related to political time. There are a few exceptions, and if you fall within one of those exceptions, then as a full power AM or FM, you have to comply with the political file rules, which can be very complicated and time consuming and frankly cumbersome. But it's an area that the FCC looks at very, very closely during renewals. In most instances, if, for example, a qualified candidate participates in a non-exempt program that's aired on your station, exempt being a bona fide news, magazine type show, there are a few exceptions. But if a qualified candidate is on your air and his or her voice is recognizable, then that is deemed to be a use under the FCC's rules, at which point the FCC's political rules kick in. Because non-coms cannot sell time, they are not required to give reasonable access to political candidates, meaning you do not have to provide time to any political candidate. But if you do, even in the circumstance that I just described as an example, then you have to offer equal opportunities to every other qualified candidate in that race. Just that race. Not all races, just that race. So that one, and then if you are required to provide equal opportunities, the opposing candidates have to ask for it within 7 days. If they don't, they are not entitled to it. If you did have to provide time, you don't ever have to provide it, you don't have to provide free time, but if you have a situation like I described, you would have to make equal time available because you can't sell time. You didn't sell the time that was used that gave rise to the use, so it would be free time if you have to do equal opportunities. At that point, you have to put the notations, the required notifications, in the online public file. Has to be done within 24 hours of the request for time. It has to indicate who the candidate was, what the issues are, has to be uploaded within 24 hours. That's been a big area of concern for the FCC. But as I said, for the most part, non-coms aren't going to have to comply with the political rules. Editorializing related to political, and of course we're coming into a big political season, so be careful here. Editorializing, you can editorialize on your station. It should be either a board member or the general manager, and it should make very clear on the air that it is the opinion of the station or the board. You cannot receive any remuneration from a third party, whether it's non-com or commercial, to air that editorial. You have to be careful of whether you're describing an issue of national importance, which you're allowed to do, but describing versus a viewpoint. The more time you spend talking about a viewpoint, it looks like you are supporting or opposing an issue, which you're not supposed to do as non-coms. So where's the line? It's a very difficult line. It's okay to talk about issues, but be very careful that you're not being so exuberant in your handling of an issue of national importance that it looks like you're promoting a particular position. You're not really allowed to. It's a very difficult line. If you have questions, it's one of those things, much like underwriting, which we're getting to next, where the words that you use are actually very important. Words, words, words. So you got to be very careful. Honestly, the editorializing is again, there hasn't been a huge amount of FCC enforcement on it, although they have flagged the fact that they're going to be enforcing it. It's a sticky wicket. There's not a lot of cases out there, so we can't give you a great deal of guidance on what is okay and what is not okay. What I would go back to is be careful of your words. Remember that you as a non-com are not allowed to advocate or endorse. Nothing in your editorial can be candidate specific. Nothing. You may not mention candidates. You may not take a position for or against a particular candidate. You can talk about issues. You can't talk about candidates. You can't talk about specific races. You can talk about ballot issues as long as you're not talking about a particular candidate. So just, I would admonish you to be very, very careful with editorializing. Then, I think the last issue we've got is underwriting, which is always the biggest issue we discuss here and leads to the most questions. And I'm not gonna go into great detail because you guys have heard me give this spiel for 20 years now. But remember that as non-coms, under the Communications Act, you can't sell ads. What's an advertisement? An advertisement is programming on your air for remuneration that promotes a service or a product for a for-profit entity. Those three characteristics have to all be met for it to be deemed an advertisement. All three of those prongs have multiple subcategories that should be considered. Most of you are very, very well versed in that stuff because you've been operating stations for a long time. But all three have to be there. Non-coms can air spots for non-coms, paid or unpaid. That's not a restriction because one of the restrictions is they're airing spots for a for-profit entity for consideration, promoting a product or a service. If you're non-com, you've met one of those prongs and you're no longer subject to the restriction. That said, bear in mind that if you are airing a spot for a non-com or a commercial entity, you have to also look at who's benefiting from the spot, from the underwriting spot. Underwriting is supposed to be identifying who the sponsor is, who your underwriter is. You're not supposed to be promoting their business. So you have to be very careful, words, words, words. You have to be very careful how you present it. It can't be a call to action. It can't be a full list of every service or product that a business has. You know, if you're talking about a florist shop, you can't say that they've got roses and peonies and petunias. And you can list 2 or 3, but you really shouldn't go much further than that. The more you list, the more it sounds like a promotion, even if it's strictly factual. You don't want to do lists. It's okay, because your goal is to identify your sponsor, it's okay to give their name, their location, their phone number, their web address. It's okay to use their brand name, trade name. You can do a short list of services. Value neutral. You can't use comparative terms because that's promoting. It can't have a call to action saying, come and see us. You can't say, we've been around for 54 years and we're the best there is. You can't say, come in now and you'll get a bonus, or you'll get a discount, or you get a special interest rate. You have to be very, very careful of all those things. Consideration, remuneration. Remember, it's not just cash. Lots of things count as remuneration. If you have a for-profit entity that is actually providing you programming or providing program production services, that's remuneration. Be careful. In-kind contributions, like programming. That's a good example. And the programming itself can be remuneration, so be careful of that. And remuneration need not be just from the sponsor, not just from your underwriter. The underwriter can be working with, for example, go to a movie. You know, go to a movie house. But movie houses often have a separate company that provides their food services. So there could be an advertisement where you're an underwriting spot, a sponsorship spot that, you know, has you going to, that's sponsored by the radio house, the movie house itself. But if you go, you would get free food. Now you got a problem. Have to be careful of where the money is flowing from, where the money is flowing to, where the benefits are flowing to, whether the station will receive any benefit from the underwriter or from an ancillary service provided through the underwriter. So with that, I'm going to, one thing I did want to talk about was there's an exception, and we've talked about this a little bit in the past, a transitory event exception. As non-coms, you can actually air spots, can't receive remuneration, but you can air spots for a commercial entity if it is for an event that doesn't happen all the time. You know, it's a very specific event. It's going to happen in 2 weeks, or, you know, it's going to happen every 2 weeks for a month, but it's not going to happen all year long. It's a special event. And it's something that the station actually thinks is something that the community would be very interested in, and it's that you're choosing to air like a community calendar spot on the airing of, and I'm going to forget the name of your movie that you're going to this afternoon. Yeah, you could actually put that on a community calendar spot, and even though the producer of the movie is commercial, and it may be airing at a movie house that is commercial, but it's a temporary thing. If you're saying there's a viewing of this movie on Thursday afternoon that's, you know, relevant to our community, you can do that. You can't receive remuneration for it, but you can air the spot because it's of relevance to your specific community and an issue that's relevant to your community, and it's not something that's happening all the time. It's a, you know, it's a transitory event. But be careful of that, because if you do too many of them, then it sounds like you're violating the rules. but it's an exception. There's not a whole lot of cases on it. So again, you know, I feel like I'm always saying be careful, be careful, be careful, but be careful, because there isn't a whole lot of case law on it. So we don't have the ability to give you a whole lot of detail on what's okay and what's not. But it does allow you to then, you know, air a spot on events that are coming up in your community. So with that, that's the end of our legal spiel. And is it time for a break? Or
yeah, we're going to break for 15 minutes because we're all full. And then we'll come back, then we'll start doing questions.
Yep.
Yeah? And
Absolutely.
if there's anything in between that you forgot, throw that in too.
Okay.
So streaming will be back in 15. Okay, we're streaming now. Those of you who are watching us streaming, send your questions to Bill over the list server. Couple of things. The t-shirts still are available for you guys to buy if you want to get another one. Christian will be able to get you that upstairs. Lunch is on your own today, but because it's Cinco de Mayo, we should all have tacos or empanadas if we can find them. So, questions. My first one is this. Bill, here's the mic for you. Far as sending the signal to the transmitter as you give notes to the FCC, please say we would like to stream that. I know it's a big deal though. So
Understood.
Let's let them hear would be very helpful.
Okay.
Instead of over air.
Yep.
And I know that's how it's always been, but maybe there's some grace there.
Yep. You're not the first person that said
Yeah.
that. A lot of my clients.
And I'm
have
pretty
said
sure everybody would have that same Well, is there anything too hard for the Lord? Okay. I'm debating between Mike and Joey in the amount of questioning. Anyone over here have a question? Yes, Maureen's going to start.
I have a question that may or may not be your area of expertise. Do you have any comment on a case where a church is approached by a cell phone company, looking to lease land on your church property location for their tower?
Sure, that's completely legal. There's nothing that prevents the church from being able to enter into a lease with a for-profit entity for tower space or land or anything else. You just can't advertise it. You can't do it. You can't underwrite it on your air. But it's absolutely fine. And in fact, you can use the income that you draw from that lease. From cellular leases are great. You can finance your operations with that.
Do you have any comments or cautionary words to that?
Treat your lease as if it were a commercial lease. Just, to make sure that you have the same protections in your lease that you would if you were, a commercial entity or anybody else trying to lease land, so that you have protections. You as the lessor should have the upper hand and the ability to terminate the lease or force them off for breaches. Cellular companies are notorious in trying to make the lease, give themselves the upper hand, but you don't have to comply with that. You have the control. It's your land, it's your tower, it's yours. So you can simply say no. At some point, you have to balance the interests on how much you want the lease and the income from that lease in what you're willing to give in a negotiation in order to ensure that you're going to get that lease. But there's nothing that says that you can't do that, and we certainly have people in office that can review your lease for you if you'd like.
Thank you.
Sure.
This side still. Yeah.
Sorry, I didn't mean to.
Thank you. I'm Gary Groover. I'm with Pastor Tom's radio stations here in Lebanon. We have a situation that came to mind a couple weeks ago for me. We have the FM station here. We have an FM translator over in Redding City. EAS issue. Are we required to have EAS coverage for Redding City through that translator in a separate unit, or can it be all covered just by those EAS here in Lebanon?
It can be, I believe the answer to that is it can be covered here. Now that, Bob, I may have to have you help me with the technical aspects of it, but from an FCC perspective, if the programming of the FM here is being rebroadcast on the translator there,
yes,
then if your EAS interrupts your signal here, then it's going to automatically interrupt your signal on the translator, right?
Yes, absolutely.
So you don't have to have a separate unit as long as the EAS at the primary has the ability to interrupt the signal that's being retransmitted.
Okay, my main concern was this is a Harrisburg operational area. Over in Redding is a totally different operational area.
Doesn't matter.
The thunderstorm warnings would not follow.
Doesn't matter as long as the equipment that you've got is actually interrupting both facilities, the
Okay.
translator and the primary, then you're fine.
Super. Okay, thank you.
Mm-hmm.
Bill, why don't you give a question from online before we hit Mike and Joey? Oh, okay, never mind. Mike. First of Mike.
Okay. So, just to muddy the water, in this translator window, I realize that there's a lot of information that you do not have. But if, let's say, an LPFM is in a certain area, and I, as an owner of a full power, decided to get a translator adjacent to the coverage area of that LPFM. You mentioned that in this window, the translator and the station originating programming are bound in perpetuity to each other, right? If I got a translator in that area and said that it was going to rebroadcast programming from, say, the LPFM, and we're completely legally separate entities, is that allowed? Or would that be allowed in this window? Knowing full well that essentially you've gotten a translator that you're never going to be able to use yourself because it has become bound to the LPFM?
The answer, I think, is no, but it's kind of a permutation of a broader question, so I'll put it on my list to check with the staff on it. But I think the answer is no. I think that from an FCC perspective, the translator will have to be used with the primary and only with the primary that it was filed through. So if Solid Foundation files for one of its FMs, then that translator will have to be used with the Solid Foundation primary station. Okay. It'll be listed in the application, and I believe that's going to be the limit of it. But it's a permutation that I will ask the FCC staff and see if I can get a read.
Okay.
Okay.
And the next question, it may have been obvious to everybody else, but I'm going to ask it anyway. So if we have 3 full power stations, the 10 application limit is per legal entity or per FM station?
I think it's per station, but I'd like to go back and look at, I actually have the public notice with me, and I think it's per station. I think, but I'm not certain. So let's not hold here. You know, when I have a minute, I'll take a look at it and get back to you on it.
Okay. And so my last question before I give the mic back is going to betray my terrible attitude towards the FCC. And as we all know, the FCC never makes any mistakes.
Never.
And is a very introspective organization and understands their own failings and limits. When it comes to the timeliness of filing things like your program's issues list, let's just say, and I know this is a stretch, that the FCC is on the 7th or 8th contractor for running the website. And again, a bit of a stretch. Let's just say the website goes down for a long stretch of time. There were rumors and murmurs that, well, okay, if it doesn't come back up in time, that's not really going to be technically held against you because how could they? But, and this is where I'm looking for some correction and information, I never saw anything or could find anything in writing to that effect. It was just all hearsay. Do you have any knowledge or anything in writing that you've seen that says that, yeah, they were down 11 days and, you know, you couldn't post your issues list in a timely way, but you did the second it came back up, that you're going to be okay?
In specific instances of downtime, the FCC has put out a public notice. I believe at least in one case in recent years that I can remember, but there's no general rule, and the FCC holds licensees to the deadline without any mercy or consideration for the health of their website, be it running by dial-up or whatever means they use.
If the website is actually down at the deadline, then they'll issue a public notice extending the time. For example, as they did when the government shutdown occurred, there were certain filings that were supposed to have been made, and they automatically extended them, just as they automatically extended the LPFM window because of the government shutdown. But as a general rule, they take no responsibility whatsoever for their site not working, even though they require that you use it. They take no responsibility at all.
Would it behoove?
And to be fair, the staff at the FCC is as frustrated as we are.
Yeah.
They had to you know, hire out a contractor at the lowest price that they could possibly get. And unfortunately, they didn't negotiate their contract for those services terribly well. So the contracts didn't have benchmarks that would give the FCC the ability to fire the contractor if they didn't meet deadlines and, you know, have systems working. So the staff is very frustrated too. I mean, I will tell you that I'm in contact on an almost daily basis with Jim Bradshaw from the audio division to talk about website issues. And, you know, poor guy is pulling the very few hairs that he has left out. So the answer is there is no rationale with the FCC.
Given that we are held accountable for something that we can't control.
What I would say is if you end up having to file something late, then put a notation on the report saying you tried to file on time, the FCC's website was down, and you filed as soon as the website would take it. Because we can rely on that in a renewal.
Well, and that was my next question here is there any data, screenshots or whatever, that I should save, you know, time-stamped? Just hear me out, right? They are in a mood, they decide to say, well, looky here, you filed late. What would I need to have on hand to charge the hill, so to speak, and say, your site was down, I'm sorry, but...
There's a couple of things that I would recommend. Take a screenshot of your file system that shows the date that the document was prepared, and if it was modified, the date that it was modified, and provided that those dates are before the deadline. I would do that. And then if you take a screenshot of the FCC's website when it fails on you and somehow document at that time the time that screenshot was taken to prove that you don't have the ability to upload something, then I think you're safer and we can rely on that. The problem is, and you need to bear this in mind, that from an FCC perspective, while the deadline for uploading issues programs lists is the 10th of the month following the quarter to which the report applies, they don't expect you to wait until the 10th day. They expect, and now that doesn't get around your comment on the 11 days of it being down, but they expect you to have it uploaded by the 10th, but they don't expect you to wait until the very last minute because of the overload issues that often happen with the FCC's website. So while you're absolutely within your rights to say, I was unable to because your system didn't work, I would also admonish you to start early where you can.
Okay, understood. So my last question is in regards to underwriting. And I've now run into this twice. This better? Okay.
Yeah.
I've now run into this situation twice, and I just want to get some clarity. I have two businesses for which we are running underwriting sponsorship announcements. We're very careful with our wording. I've heard you say this, you know, and however, the interesting thing is the names of the businesses would set your hair on fire. One of them, and I'm going to adapt it just so you get the idea, is the best carpet cleaning company ever. Is like the literal name of the company. They use it on their vans, it's all over all their advertising, it's their slogan, their identity, blah, blah, blah. That's comparative.
Right.
The best carpet cleaning company ever.
It is, but it is their legal name.
Okay, so the fact that I happen to mention their legal name in that underwriting sponsorship several times, the best carpet cleaning company ever, because it is, I am identifying the entity, right, is okay?
I think legally it would be okay, but again, I would admonish you probably in that circumstance to repeat the name fewer times. just to protect yourself for the obvious reason, because it's comparative, because the name itself is problematic. Now, obviously, there are many, many, many cases that say that you can identify. You can identify the name, you can identify their phone number, their address, but if their name actually is a comparative statement, you have to be able to say their name, or you won't be in compliance with the rules, where you have an obligation to identify the sponsor. So if the name is a problem, I would say the name, but I probably wouldn't say the name multiple times if you can help it.
And this would only apply to their legal name and not any slogans that they use that use comparative language, right?
Under the circumstances, yes, I would say that. Ordinarily, you're allowed to show logos or, state their logos, use their logos. But again, where you're running with a name that has as much problems as that does from an underwriting perspective, I would use as little as possible in order to protect yourself.
Thank you.
How about the distinction, Kathleen, between logos and slogans? Using a slogan, where do we draw the line at the distinction between what is permissible in terms of using a slogan versus a trade name?
Part of it comes as words, again. It's all about the words. But I would say that if you actually have a trademark, you can use the trademark. If the slogan itself is problematic, then I wouldn't use the slogan. I don't know that there's been a whole lot of case law on the distinction, but some of it is just trying to think through rationally what the rules say. Bob?
We'll
Okay.
get to you, but there's a few people ahead, so we'll get everybody included. I want to point out, Mike, that if you pay your taxes on the IRS website and that goes down, you're still obligated to pay them on time. Because the general rule is the federal government can never make a mistake. That would be impossible. And that's like saying that the God's word has a mistake in it. We know that's not possible either. So I have two questions that came in online. These are from Jeff Gallatin.
Oh.
Hello to Jeff.
Hi to Jeff. Hope the painting is going well.
Hello, Jeff. And we're going to give these two questions. Then Brad Dacus was next in line, and then we'll get to everybody else. So two questions from Jeff Gallatin. First of all, programmers that pay for airtime, do they need to go into the donor list?
If they are paying for a particular program, then they need to be on the donors list. If they are paying in just generically to help support the station's programming, no.
Okay.
The distinction is on a per program basis. If they are supporting a program in particular, then they have to be on the sponsors list. If they support 3 programs, then they would have to be on there as supporting those 3 programs, because the notation that you make in the public file is specific to the program. You indicate the program that they are supporting.
Okay, thank you. So his second question was EAS tests and logs. Do they need to go in the open public file, and if so, where?
You want to handle that one?
No.
No.
That's a simple answer. No.
Yeah, you have to keep your EAS
You have to
log
keep
at
them,
your
and you-
station.
Correct. For
And
2
you have
years.
to keep it for 2 years.
Yep.
And by the way, I'll just add, we have a notebook, and every week we put the EAS log in there, and every week we remove the log from 2 years ago. So we always only keep 2 years, because keeping extra of anything never can help you, but it can hurt you.
Right.
If they look in there and they see a mistake. So you get rid of it. Every 2 year, at least monthly, I would say get rid of that old stuff.
Same with the
that's
online public file.
If anybody else online is listening, please send your questions to the list server, and go ahead, Ron.
So let's say you have a candidate, John Doe, and he says something outrageous saying all Christians should be kicked out of the country and sent to someplace. Cuba. Let's say, Cuba. So, and then you've got someone who has a program and on that program, the person says, I can't believe John Doe said something so outrageous as saying all the Christians should be sent out of the country. I think that's outrageous. I cannot imagine why he would say something so awful like that. is that crossing the line, or does the person? I know I'm super careful in terms of anything political, as far as politicians, or even saying a Republican or Democrat. Or does that person have to say, or does the program have to say? Now, I'm not saying who to vote for, who not to vote for, but I have to point out, do they have to have that qualifier? Or I imagine you would recommend that qualifier probably.
I would recommend that qualifier.
Yeah, but if they don't have that qualifier, did they cross the line by just pointing out a specific thing that a candidate John Doe said or did?
The answer is, if the person making the statement is not from the station itself, then I think you're okay. But I would recommend the qualifier in any event.
Yeah, you're just talking about a program that you're airing. Right. Yes.
Right.
Yeah. Okay, Joey's got like, I don't know, 35 questions. I'm going to take a nap.
Jump in. Don't let me
So that was actually one of my questions. If a programmer brings up, statements about issues or politicians or whatever, that's less of an issue because it's a programmer that's not produced by the station. It's a program you carry, right?
Is it commercial or non-commercial?
The station's non-com.
No, but is the programmer commercial or non-commercial?
Like a Brad or a pastor, or they say something. Yeah, non-com.
Okay.
Yeah.
Okay. If I understand your question correctly, you're asking whether or not that's okay. Technically, no. I mean, if it is candidate-specific, you cannot do it. If it is related to an issue of national importance, you can cover it as long as you are not promoting or saying you're completely against something. But if you're covering an issue of national importance, you can do that as long as you're not receiving any remuneration. And then you have to put something in the public file.
So, and again, you can, I ask specifically about my situation because I think that is easier to answer. If you want to apply it to full powers or whatever, you can answer both. But as an LPFM, a programmer, right? Whether it's me, him, Ron's.
Programs on your station, and I say that. Joey's asking. Yeah, Joey's asking. He is running Boldly Speaking on Joey's Miami station, and I say something on a comment about a recent political figure said X, Y, and Z. That's what his concern is. Is it on him? Because the management of Miami is not making the comment. It is my program, to which I'm not paying him to be on the station. He is just airing my program. Yes, that's your question.
Yeah, okay, thank you for the clarification. And I think the problem goes back to promoting or expressing an opinion that's absolutely contrary to a particular candidate or a particular
So are you
political-
saying that maybe we should start airing once a day something that says the views of these programs do not necessarily reflect the views of management of WXMB?
I think that would provide you some protection, but I think you have to be very, very careful how far you're going with that kind of program.
The problem is
because you're really not allowed to.
The problem is he is not listening to every single program that's 26 minutes in a 24-hour period.
But
And again, I'm not trying to be controversial or whatever.
no, understood.
These are real world issues that I'm seeing, and for now at least, I don't have like a bunch of emotions about it. I'm just seeing things transpire and trying to respond accordingly. One of the things that I'm seeing is some programs are featuring guests, right? So a program that would have been pastor so-and-so, now they're transitioning their pulpit. They have assistant pastors or guest speakers on their program that I didn't know were going to be there. So now, not only do I not listen to all the programs, we're getting guest speakers on programs. Secondly, and again, I know pastors are called to certain things. There's certain pastors that are very political. They have interviews from the pulpit. They have candidates on the pulpit. I don't air many of those programs, but if another pastor got an idea to do a candidate interview from the pulpit, like these are things that are actually transpiring and affect many of us.
Okay, so even if you're not listening to every single program, as Ron said, it's still your responsibility. Okay. So if you've got a pastor, extemporizing from a pulpit and they are speaking of a particular candidate, you are in violation of the rules. Okay. You cannot be candidate specific.
So everybody has to drop boldly speaking.
Yeah, no, I mean, I've reached out to some of the programs and said as much. Hey, if this happens again, we're gonna take you off the schedule.
Right. Put them on your website.
Yeah, yeah.
Just don't do it on the air.
And then, so that was that question. Yeah, and then, I mean, I guess, and this is maybe a question for us as pastors and leaders, but right, so I guess it's a question I'm going to be asking myself, right? Like, how much do we toe that line, right? Like, we're not going to stop talking about abortion or gender dysphoria because it is a gray area of national issues of importance, right? So it's going to be stuff we're going to be asking ourselves. Okay, what if a listener brings it up and you're responding to a live call?
No. I want to go back to what he just said.
Well, what he just said, my thought is, if it's an issue of national importance, then the station can have an opinion on it, and you would need to put something in the public file. Oh, well, you're LPFM,
low
so you don't
power
have a public
FM.
file. But I'm sorry.
On a low power FM?
No, there's no
Yes.
public file
Yeah.
for a low power FM.
Yeah.
So you don't have to put something in your public file.
So-
but I would keep records of it just in case the FCC came in and
His
started
point
asking.
is valid. We have pastors that are teaching and programming that eventually gets on radio. And I'm talking about a national issue in front of our congregation, and it's about abortion. And the next administration is pro-abortion. Is that now in their mind crossing the line? And now we have to censor every single program because that administration is too sensitive to it's like now we're censoring all of our pulpit conversations because we know they're eventually going on the radio.
Right. There's no absolute answer. I'm sorry to say, there's no absolute answer to that, but keep it away from a discussion of a particular person or candidate specific. You cannot be candidate specific, and technically you are not supposed to promote or...
Even party?
No. Party I think is okay, as long as you are not being candidate specific. But again, the lines are gray. It's really difficult. I mean, the further you push it, the more likely you're going to have problems.
Right. I mean, I'm thinking of a scenario with like Lloyd in Jersey, where he's standing in the pulpit and he's telling the congregation, hey, the governor just signed this. And that is going to be on the radio in 4 months. Yes, everybody? Tom, are you going to not say that? What's our problem now?
The governor's not a candidate in
Right.
the race, right?
But
Exactly.
but he will be.
He's not now, though.
But
He's
he
not
will
now.
be.
He's not now. He's
He's
not a
not
candidate.
now.
So
and
you're
if he
saying
wasn't a legally
if somebody's in
qualified-
office right now, it's okay.
Generally speaking, yes.
So if I say something last time about Biden and going after Christians from the pulpit, I'm fine. Even if that airs 4 years later when he is running. Because that happens all the time with my programming. It gets replayed several years later.
You need to get some new programming.
Well,
I would say if it's
I don't know about
if-
you, but it takes me a while to teach through Genesis. So,
I would
Yeah.
say be careful
Yeah.
if you're rebroadcasting something 4 years after it was stated. It clearly, if the person is not a qualified candidate,
Yeah.
then.
but
then
you understand what I just
I
said.
do
yeah?
understand what you just said.
Yeah.
I do understand
So
what you
things
just
get aired at a different time. But so everybody's clear. I just want everybody to be clear online, and all the pastors that record stuff, then if it's a current politician or a current issue, it's fine. It's just now that person's running. So Gavin Newsom running for president in the next whatever, we can't say anything about him.
Right. Well, technically,
But
that's
he's-
true.
so
He's not a
until he
legally qualified
declares-
candidate.
See, I'm pretty sure nobody really knows that, right? Yeah, just start cutting my programs off. So what if a listener brings something up on a live call?
I'll give you the exact example. This was a couple years ago, I don't even remember, but it's the only example I have, and so I'm like, oh, what if this happens again? A listener was very antagonistic towards President Trump, or candidate Trump maybe at the time, I don't remember, and making accusations, oh, and they built cages for people, and they're putting people in cages meant for dogs. So then I responded with, actually, unfortunately, the facilities you're referring to were built by the Obama administration. You should take it up with him. So I was responding to a listener because I want to serve our listeners.
I actually suspect that that's okay, but
You understand, though. I mean, we're in a sticky spot then if this is going to continue down that path. Yeah.
Understandable.
Sure.
Because Mike, myself, I mean, we're running 24. How many are you running? 24, 30 different pastors on your stations every single day?
Right.
I mean, yes, none of these guys are dealing the issues that we're dealing with. This is our specific issue. And again, I'm not going to not say anything about that particular issue. That's important.
You can talk the issue.
Yeah.
Just don't talk the candidate.
Yeah. The problem is the candidate is tied to that issue.
Understood.
And as long as I don't bring up the current, they're running for that office candidate,
right.
That's what you would say.
Yep.
Right.
So, okay. Everybody got that? Yes, Lawyer? Brad Dake has got that? That's important. But, Ben, we're sitting in the pulpit every single week, Wednesday, Sunday, teaching. And, yeah.
You know, a bigger problem is, if I could address it, it's tangentially related to it. A bigger problem is that some of our programs add commercial announcements to them. Books, trips to Israel. You know, if you're promoting a trip to Israel, you're promoting a travel agency, an airline, hotels, restaurants. Those are for-profit businesses. And people ask me this question all the time. It comes up on the listserv all the time. And it kind of gets me frustrated because I feel like saying, what don't you understand about the words for profit? If we go to Israel, I love Israel. I want to bring everybody to Israel. I can't wait to get back to Israel again. But there are people making a profit when we go there. And I took Greg Laurie's program off because they were promoting the movie and sending you to the local cinema to see the movie that he made. And the local cinema is a profit-making organization. The company that made the movie is profit-making. They're all profit-making. If they're selling books, buy our book on Amazon. Last time I checked, Jeff Bezos was in business to make a profit. So we don't do that. You know, you cannot advertise for-profit businesses. And I would suggest to you, this is much more common than this political question. I mean, the political question is very serious, but what you can hear any day of the week, and if you don't aggressively watch these programs, and when I talk to the people that produce Greg Laurie's program, oh, well, we've been doing this for years and we didn't know that. And I said, well, then you're incompetent if you've been doing it for years and you didn't know it, because you may not promote a business. And you know what? I have too many licenses to risk. So I'm just not going to do it. I don't need your money, and I'm not going to carry the program. It's real easy for me. Just don't promote things for-profit businesses. And if there's any doubt, then pull the plug.
Yeah.
Okay, well, we answered 2 questions. No extra charge for that.
Now, bear in mind, I do think there's one very, very small permutation to Bill's answer or discussion there, and that is if you are, the transient event exemption applies if you're using the trip to Israel in a community calendar type situation where you're not bringing it up in multiple spots every day for 2 months before going to Israel. If what you're doing is adding a list of events, you know, there's a showing of this movie at that for-profit movie house 2 weeks from now, then I think you're fine, because that's a movie that's relevant to your community, and it's transient. It's not every week. It's not going on and on and on. It's a community calendar type notice. That I think you're okay, because there you're looking at the community nature of the announcement as opposed to the financial remuneration redounding to the station. And that's the distinction with the transitory exhibit. You have to be looking at something that is good for the community and not looking at making that announcement because it's going to have a positive remunerative impact for the station. And obviously remunerative there doesn't mean cash. But I think Bill is absolutely right that you can't advertise trips to Israel on a regular basis. But the way to get around that is to use a community calendar type announcement and send people to your website. The website can put anything and everything on there, and the FCC does not control that. So it's on the air you have to be careful of, but you can get people to go to your website. And there you can say whatever you want to say. So.
Okay, going back to listing your donors. Mm-hmm. There are programs that pay for airtime on our stations. Okay, they then are for their own, they pay just for their own airtime. They then are considered donors to the station, is that correct? And need to be entered on the public file?
Yes.
Okay. It wasn't clear whether we were talking about our underwriters that are, sponsor any particular program, or the organization itself is paying for their airtime. And by the way, we have people who we have programmers who provide share revenue, but they're still giving you some of the share. So they need to be listed as well as the paid programmers need to be listed. Is that correct? Okay.
Yes.
Derek, you're happy with that? Yeah. Okay.
I think if you could correct me if I'm wrong, but if some person or organization is paying to underwrite another program, like I like program XYZ, I'm going to donate to your station so you carry program XYZ, then I think that person would also need to be listed on the public file. Is that correct?
As long as their donation is specific to the program. If they are saying, I'm donating to the station because I want this program, then I would say, yes, you should list them, just to be careful. Even though that isn't absolutely directly tied. They're not saying, I'm contributing to this program. They're saying, I'm contributing to your station because I want this program. Then I would say to err on the side of being careful and disclose it in your
I think there the because would be right. What leads you to list them on the donor list, as opposed to, I like X program, I'm sending you this contribution to your channel. Yeah.
I agree with that.
As far as underwriting a nonprofit that's underwriting, I understand this is an oversimplification, but is it kind of nonprofit so none of those rules apply as far as qualitative and all that stuff and what you're careful to say and not say? Hey, the Lotus House for women, go by there, go take all your stuff, donate, send them money, they're great.
You can
they're
do
the
it.
best women's shelter ever outside of Lebanon or whatever.
You can do that.
All right, cool.
How many more do you have? That was it? That's all your questions? I don't believe it.
Okay, we have...
Not for a second. You have another one online?
No, Mike had a question here, but we'll let Tom go first.
So just a couple questions. I realized after Mike made a statement that all we have to do with our sponsors is have them file with the state for doing business as the best pizza house in the state. And then it's a legal name. No, I'm just kidding. I'm just kidding. I'm curious.
Good.
Yeah. The GMR, do they handle any Christian music?
It's very, very small from what I understand. Again, I don't do music licensing. I think there's very, very little, although they are trying to get into the Christian music space.
And there are we have some programs. Jack Hibbs is one. I've heard Jack Hibbs mention specific candidates. And I don't know how you monitor all that, but I have heard him in the California race mention specific candidates to vote for. And he's on air.
He really shouldn't. And the question is whether or not somebody actually files something against him. The FCC pretty much, although this political season could change things, particularly with this commission, but right now the FCC won't go after somebody on a violation like this. They wait for somebody to file, and then they'll pursue it. I haven't seen them on their own motion going forward with things.
So I just need some clarity in this next thought. So let's say we're in a revenue share, and the revenue share is through a for-profit agency.
Ooh.
And on the program that they sponsor, they do call to actions.
I think you got a problem there.
Okay.
I think you got a problem there.
Because there are agencies that sponsor. They're national, Apex and different agencies.
Well, yeah, I don't think you can do that. I mean, if the underwriting spot is aired in the midst of that programming and they are the sponsor of the program and the spot.
I'm not saying that. I'm saying that the revenue share is paid to us by an agency that is a for-profit agency representing a nonprofit church. Not like, say, David Jeremiah. Let's say he has an agency that is a for-profit. The money is coming to us from a for-profit. But on his program, he's doing a call to action. Call to give, yeah.
You stumped me.
Okay.
I honestly don't know the answer to that. My gut says it's problematic. But I don't absolutely know. Let's follow up on that afterwards, and I'll pursue.
One last thing is I suspect that, as politics are becoming more and more divisive, we're going to need to listen more to who we have on the air. Because they're getting more political all the time.
I agree.
Quick question, a point of clarification, if you will. So, Jack Hibbs. Jack Hibbs says everyone should vote for Steve Hilton. This is clearly the best candidate. That would be clearly wrong.
Absolutely.
However, let's say he says, by the way, did you hear what Jack Hibbs said about the need for supporting religious freedom? He says, I thought that was a really good move. I think we need to support religious freedom. Or conversely, candidate Becerra came out and said that all Christian schools should be shut down. Folks, this is really serious. We need to be really committed to supporting our Christian schools. So what I'm saying is, I think there's a distinction, correct me if I'm wrong, I don't mind being corrected, but I think there's a distinction between saying, vote for the candidate, or this is the best candidate, I support this candidate, versus referencing something a candidate said and then commenting about that as it applies to, from a Christian biblical worldview and why we need to be concerned. Is that an accurate distinction or not?
I do think it's an accurate distinction, but I would admonish you that we are going into a very, very contentious election period.
Right.
So I would be careful.
That's at the edge of the cliff is what I would say.
I agree.
I would say technically, yeah, you haven't fallen off the cliff, but you're right on the edge, so that's, yeah.
I know someone that'll defend you.
Yes, and we will defend you, by the way. Anyone here is for free, as long as you haven't gone off the cliff.
Yeah.
We will defend that speech. So.
A lot of my questions were to go home and share with on-air talent.
Sure.
Right, like what to say, what not to say, what are endorsements, what are not endorsements, how to right? I forgot the technical term you use. Editorializing.
Oh, editorializing.
Can you define that? I don't know if I got that. Oh no, maybe not. Maybe
No.
you're not allowed. I don't know.
No, I can't. It's an opinion of the editorializing specifically is an opinion given by the station or the board of the licensee. So it's fairly narrow, and again, you can editorialize, but the more opinion you give, the more it looks like you are promoting or opposing a particular issue, and you're not allowed to do that.
Well, so I'm a little bit more confused now. I thought the rule was only candidates. So again, and whatever, right? We're here to learn.
Yeah, yeah.
If we're promoting an issue of preserving human life actively every single Friday from 3:30 to 4 with a pregnancy center,
You can do that.
editorializing?
No, you can do that. Well, perhaps you're editorializing, but if it's programming and it is not, think about the nightly news. You sometimes see the general manager of a station or the owner of a company get on there and they do an editorial piece. That's editorializing. If you are doing a program, a regularly scheduled program that deals with abortion or immigration or LB, whatever it is, GTQ, I can never spit that out, then if the program is regularly scheduled, you're talking about issues of national importance, and you can do that as long as you're not being paid by a for-profit entity to do that. You can do that. You need to put a notation in you probably should put a notation, your LPFM, sorry, you don't have a public file, but if you were an FM or an AM, then I would say you're dealing with an issue of national importance. I'd put, it's an issue ad per se, and I would put a notation in the public file just to cover yourself. But it isn't editorializing unless you've got a talking head giving an editorial.
Which we sometimes do, right? That's my question. Because it's something that's regularly talked about in the station, we go live twice a day. So I have 2 times a day that somebody might editorialize, right? I have 3 hosts plus me, so 4 of us. They might start talking about issues, like the issues, right? Just because they feel like it that day. That would be editorializing.
Yes, it would be. In that instance, what I would do is admonish you to make very, very clear that the positions stated are the position of the station and or the board.
Because that's the safe route.
It is the safe route, and generally speaking, with editorializing, the FCC wants to hear that.
Because what's the alternative? This is the position of somebody.
If you're simply speaking, then it could be broader, more broadly taken, construed is the word I'm looking for, that you are representing the opinion of somebody beyond yourself, of a candidate or of a for-profit entity that's talking about an issue. Okay?
Okay, so let's leave the political with this. We'll just move on from political so in the advice of our lawyer in the room, thank you for Brad for being here, you are telling us that in the upcoming season, it is your recommendation to tell all of the pastors in the room and online to not mention a candidate's name.
Yes.
Or just turn your transmitter off.
Yes, but
The answer, Ron, is
I
yes.
mean, Bill jokes, but we have not talked about this before.
Brad asked how close
Yeah.
we get to the line, and she said
Yeah.
she described as good to go.
Yeah.
I think my perspective is that you're at the edge of the cliff. You're not falling over if you say, candidate so-and-so said this about abortion, and this really bothered me and then you focus on the issue. Referencing I think is distinctively different, and I think it's very defendable as not endorsing a candidate.
I agree.
Yeah, so I've seen conservatives say, President Trump, whatever, candidate so-and-so, and make a distinction, even though that person is supporting. So you're not necessarily endorsing or condemning a candidate just because you reference something they said. But I do agree, 100% also that to say we need to get behind this candidate or candidates like this person, I think that's where it crosses the line.
I agree.
And I think we've got to, that's my opinion. So.
It's all a matter of degree, really, in the scheme of things.
Can I just say one last thing about our pastor, Malcolm Wild, has always been, I would describe him as apolitical. And his thinking is that he doesn't want to draw people to the Republican Party or the Democrat Party. he wants all people to hear the gospel. So Republicans, Democrats, independents, communists, socialists, and that's kind of where he is, and that's been good.
Yeah, but I will say, before Chuck died, he wished he would have spoke more about the issues in California. Yes, and the issues, yeah. No, I'm not talking about candidates. I'm talking about issues. Yeah.
For example, when we're talking about people offering the babies to Molech, he talks about abortion. When we're talking about God created them male and female, then he'll talk about gender confused. And when it comes up in the scriptures, anyway, we avoid a lot of headaches.
Precisely. It's words. It's words. It's being careful with your words.
So here's something to always keep in mind. Be anxious for nothing, but in everything by prayer and supplication, with thanksgiving, let your requests be made known unto God, and the peace of God, which surpasses all understanding, will guard your hearts and minds through Christ Jesus. Hey, use wisdom, use discernment, do the right thing. God will show you by the Holy Spirit what the right thing is. And if you get in trouble, you call one of our lawyers. Praise the Lord. So some quick questions here. Some quick questions. If somebody is donating to the station as an underwriter, and we mention, we like to thank Joe's Plumbing for their generous support of Hope FM. Does that person have to go on our donor list?
No.
No. What's the distinguishing mark between that and someone paying to have a program put on our station?
A particular program. If you are putting on a program, Mike does a weekly program.
Okay.
And that person is contributing to that program so that it is aired on your station.
So mentioning Joe's Plumbing is not a program. No. Now what about if Joe's Plumbing says, I really like the way Jack Hibbs promotes Republicans. Can you play my promotion just before Jack Hibbs's program? He's still not a donor on the donor list.
I don't think you'd have to put him on the sponsor list, but I think you might have a problem otherwise.
Well, no, he's not saying anything other than I want my announcement to be near that program. I mean, people.
To be safe, I'd probably put him on the donor list.
Okay.
I mean, there's not. Again, this is another issue where there isn't a whole lot of black and white. There haven't been cases on it. The rules simply say that you list donors that are contributing to a program, not to the station, but to a program. So,
okay.
If Joe's Plumbing is contributing because he wants a particular program, then it's, like Mark said, it's a because. So I think I would probably err on the side of putting him on the list.
Okay, so then this question came in from Eric Cruzel. So we'll give a shout out to Eric in Arizona. Eric Cruzel. He's asking about the programs and issues list that we put out every quarter.
Yep.
Is there any kind of a format or minimum requirement for the number of items to be shown on that list? A format or a minimum quantity?
I don't have. The answer is there is no format specifically. There is information that is required. You have to list the day, the time, the duration of the program, the issue covered. But as far as the number of issues that you have to show in a quarterly report, the guidance from the FCC and what's required in the rules say you are supposed to cover the issues, the most significant issues that you covered in that quarter. How many doesn't really matter. I would say at least 3. 3 to 5 is probably a good standard. I wouldn't go below that, but you don't have to list 50 either.
Yeah, I have a question. I was listening in online and just got here, but and I heard my mention about some of the things of the governor in New Jersey, the attorney general particularly. I mean, they just got smacked down by the Supreme Court 9-0, and yet they're still going after this pregnancy center. So my question is this: look, I'm not going to hold back what I see pertaining to an issue. Like, we've been dogged for our pro-life ministry in New Jersey, and I have boldly from the pulpit expressed, we're going to continue. When my thought is too, the Supreme Court decision in regard to relifting the ban of, the Johnson Amendment, has that not connected to radio? Is this a different issue because radio just concentrates for non-coms that any political speech is inherently valuable, so therefore it's profitable, so therefore you can't touch some of these issues if they cross over into the political realm?
The answer is, should it? Yes, it should connect. But the fact is, under statutory law, you are not allowed to promote political. So, unfortunately, they don't connect because the statute is the statute. And until the statute gets changed, and I don't think it will, without requiring you to jump through a whole lot of hoops and pay reg fees and everything else at the FCC, I don't think the rules will change. I don't think the law will change. And the law specifically says that as a non-commercial station, you cannot.
Okay, you're expressing that well. I would have to, actually, on the practical side, just like under the Johnson Amendment, as long as it existed, if there was one or two cases in the history that they went after a church because they got, and some of the Democratic churches were like going off the rails and they never touched them. So what are the odds of someone coming after us for some of these minor things? Would it be some whistleblower that's listening and complaining?
I had this discussion with Tom earlier. The answer is, how likely is it for somebody to come after you? Probably not terribly likely, although I will tell you that it is my belief that this particular political season is going to be ugly. Regardless of which side you're on, it's going to be ugly. And I think that, precisely that, it's going to be somebody who's disgruntled, somebody who doesn't like what you're saying, somebody who doesn't agree with your position that's going to come after you or come file something with the FCC saying, look at this station, they did this. What are they going to do? The least they would do would be to fine you. The worst that they could do would be to take your license away, take your non-commercial status away.
Would that be immediate? Is there like an appeal? Is there a process? There is a process.
There is a process. Go ahead.
There is a process.
Still not all there.
The pleadings that you file, somebody files, say, a complaint or an opposition, or a, and then you have the chance to rebut their.
And then ultimately the decision comes down to the FCC staff, but things are going to get ugly. Yeah. And this commission, rightly or wrongly, I mean, you saw what they're doing to ABC. They also just filed a early renewal order against an LPTV company. And from what I've been able to discern, because the problem has existed with this company for a long time, that they're going after them because of what the FCC perceives as a misrepresentation of their ownership. Meaning that they indicated that somebody was in voting control of the licensee who was in fact not in voting control, and that the person who was in voting control wasn't listed. So they're going with an early renewal. They're going after people. Now technically, the FCC has never used the renewal card or early renewals in a political situation before, as they are with ABC. So kind of all bets are off. We just don't know, which is why I admonish to be careful. I mean, let's not give the FCC a reason to go after your license. Just be careful. You're not supposed to be, doing political spots and ads. Just be careful. As much as it is so much a part of your mission and what you stand for, which I understand completely, from a legal perspective, I say be careful. That's the only real advice I can give you. And this commission is so different than any other commission that's been there in the 40 years that I've been practicing law that I can't begin to really give you any absolute solid advice because they're doing things that have never been done before. And I'm not saying it's right or wrong. I'm simply saying they're doing stuff that I've never seen before, so I can't tell you what they're going to do. I just don't know. I just don't know.
So to tie into all that, our church does some work up in Greensburg with Turning Point USA. That's a nonprofit. How does this affect any of the stuff with any of the Turning Point side of things, or no, because of them being a nonprofit themselves? But because they do go political sometimes, does that tie in as well?
I'm not sure I understand your question. Can you clarify for me? I'm not sure.
He's saying because they're a 501(c)(3),
right?
That your question is just because the station may have aired a Turning Point
or promoted Turning Point events in the area. There's concern because
and then his point
political.
is because somebody there said something political.
Oh, you mean that, are you responsible for somebody on a program that said something? The answer is, from a strictly legal perspective, yes, you're responsible for it.
We promoted the event, not the candidates, just saying they're hosting an event at this place, this time, and we don't list anything
And they're
political.
non-commercial, then you're fine.
Okay.
You're fine.
Sounds good. Thank you.
Yep.
Okay, last chance or forever hold your peace.
Well, I'm wiped out. Yeah.
You think we could milk it to death just a little bit more?
No. Tom's going to come up because Kathleen is retiring, and I just want to thank her for all the work that she's done.
Thank you.
And it really does. Look, just because I don't like what you're saying based on
I understand.
based upon the law and the FC, I know that, and I know that, but that your job is to protect us.
Right.
At the end of the day, yes? At
Absolutely.
the end of the day, the lawyer's job is always to protect us. We had a situation recently with real estate and a transaction, and the lawyer didn't do that. And it caused us a ton of grief, almost to like a lawsuit kind of. So you gotta, we're putting a lot of faith and trust, of course, with Brad and our lawyer. And I'm just saying, it's a very hard job when government changes every minute of the day. And it's like Jell-O on the wall. They don't often know. It's the best that they're doing for us. And I really appreciate that and all that you have done, Kathleen. And
Thank you.
Tom's going to pray for you and for your husband.
Thank you.
Yeah, Kathleen, we'd all just like to thank you for the years that you've given to us and the good counsel and your understanding of our Christian perspective. And so we just want to thank you. Thank you so much. Thank you.
It's been a pleasure.
And I want to share, I talked to Kathleen earlier, and she said the reason she's retiring in large part is her husband can no longer walk, and she's needing to give him some extra care. His name is Fritz. So if you want, just put your hand out toward her, and we're going to pray God's blessing. Father, we pray for Kathleen. We pray for Fritz. We pray, Lord, that these years to come would be rich and full. Lord, that their relationship would be just so strong and united, and they'd be together in such a beautiful way. Lord, give her the grace, the patience, the understanding that she needs to minister to him in this time. And we pray at the same time, Lord, you would just encourage her and bless her and strengthen her as she does that very thing. So, Lord, we thank you for her years of service, and we pray you just bless her in these years ahead. And we pray for Fritz, Lord, that you'd just enable him to be in as good health as long as possible. That's our prayer. And we ask this in Jesus' name, and all of God's people said, amen. Amen. Thank you.
Thank you.
Thank you. Okay, so Bill has a little introduction, and then we're going, who else had to do anything? We'll do you later. Got it? Before the dinner thing.
He used up all his time already.
No, this is radio applicable, so.
I just want to introduce Tim from Broadcasters General Store. You probably know Broadcasters General Store, BGS, is a provider of broadcast equipment and stuff like that. And he can't stay at the conference all day today. He's got other places to go, but I wanted him to introduce himself. Maybe he can give you a card, tell you a little bit about what they can do for you. And if you have any needs coming up, he'd be a good guy to talk to.
Well, the question is, do you have any equipment at your radio stations? Any hand, show of hands. Okay, then that's good. We're very expensive equipment, I understand that. We provide up to 600 plus lines. So if you're looking for something, we probably provide it. But we also, I'm an engineer, owner, operator as well, and I've had an LPFM. This was a lively discussion, which I really enjoyed because I've dealt with all those issues. And that's a challenge, it truly is. And you, like Brad said, take it to the line, hold on to it, but don't go over the edge, and you'll be fine. And if anything, question first. That's the key. Just make sure and double check. And if you write something, make sure somebody else reads it and then double check it, make sure the verbiage is right. But anyway, Broadcasters General Store. If you're looking for something, equipment, anything in a broadcast side from the antenna back to the microphone, we can provide it. We also have a lot of people on staff, which means if you make a phone call to us, my card's on the table, somebody will answer within the second ring. That means you're going to talk to a human being, not AI, or you're not going to have to worry about leaving a message. Somebody can take care of you. I'm here to help as a broadcast engineer, but as a brother in Christ, I'm here to help you all because I don't need to sell you anything. I'm just glad to be here. Because when I was invited, and I've talked to Bill, and we were just looking about it, and Bruce and I were talking, Mr. Weatherman, who we'll be talking to later, the key thing about is we're here to supply people with the Word of God. It's a tool. It's an amazing tool, and I love the fact that I'm working with K-Wave right now in Anaheim. It is an amazing ministry throughout the country, and you all are doing an incredible job, a truly incredible job. So spread the Word of God. That's what it's all about, and that's where God gave me the ability. That's why I'm here, and I'm blessed by that, for that fact that I can be here and present that to you. I just happen to be working with Broadcasters General Store. That's my spiel. But at the same time, I'm here to help. If you have a question, engineering, programming, feel free to give me a call. My phone number's up there. They can always put you through to me on my cell phone. I travel quite a bit, but I'm always available to you all at any time. And I do answer my phone off hours as well, so I'm not afraid of that. I think most engineers know that. If you have an engineer out here, you understand what that's all about. But I'm here to help any way I can from Broadcasters General Store. Thank you, and appreciate every one of you here. Be safe getting home and in your travels. And God bless you all for all you do. Thank you.
Thank you, Tim. And like we said, Tim's cards are upstairs on the same table as Bruce Robertson, the weatherman. After lunch, our first session at 1:30, I'm going to talk about why you should want to apply for an FM translator in this upcoming window. You heard some of the legal details about it, but why would you want to be bothered? That's what I'm going to talk about at 1:30. After me, Bob Moore is going to talk about how to go about applying for it, more of a technical presentation, and the weather, Bruce will be talking about the weather on the station. So that's coming up at 1:30. Also, I want to remind everybody, Ron will give us details for dinner. That's Mission Barbecue, which we catered in at a very fancy venue right down the street here.
Yeah, we'll have Tom help out.
Tom will tell us how to get there. Maybe he'll drive us there in his Ford if it's working today. And but go ahead, Ron.
That's just funny. Okay, so I was just talking to Robert about this, but Mike and I texted him about this a bit. If you know this, please, we want to share this point. I have a Suburban. It's a relatively new Suburban. On the screen, there is a logo on the right side. It's not RDS fed. There's some other, and we talked about this years ago, by the way, an issue. And if you turn to somebody else like iHeartRadio or somebody up, you're going to see that logo pops up. But it's not RDS. So I'm speaking to Stream and to us. If you know that, because Mike and I, we've been talking about this, and I just asked Robert, he doesn't have that either. He's texting his. We need to get our logos on these new cars, because all of these cars, I mean, our rental car has a giant screen, and that RDS is not in that new logo section. So we want to figure that part out engineering So I'm telling that to the stream, if somebody has already figured that out already, new cars, there's a submission process. I think it was Jeff Gallatin that said that, sorry, Jeff, about that years ago, how we need to get that onto the new cars. So that's just a thrown out there. Back here at 1:30, you guys are on your own for lunch, and then please come back at a prompt time. Amen. Let's pray for lunch in our time. Father, thank you for our day. We thank you again for our sessions and everybody that's here giving of their time. We just ask that you bless the food to our body, keep us safe, Lord. And we want to do all things that please you. We want all the glory to go to you.